This letter, which has Pope's official seal and signature as prosecuting attorney for the 10th Judicial District, unequivocally proves Pope entered into plea negotiations with Gaddy that extended beyond the disclosed benefit of use immunity. It proves without a question Gaddy lied at Tony's trial. Pope's sentence recommendation to Gaddy proves that right after Gaddy's arrest and confession in November 1984, Pope wasted no time in seeking to negotiate a plea deal with Gaddy in return for her testimony against Tony, an offer that was never disclosed to Tony, Tony's lawyer, or the jury. Having this irrefutable proof, Tony once again sought permission from the Arkansas Supreme Court to file a petition for a writ of error coram nobis into the Circuit Court, charging Pope with knowing use of perjured testimony and deliberately withholding exculpatory evidence. Tony felt somewhat optimistic about his chance of receiving a fair and favorable ruling from the court this time. He had actual proof showing his claims are true. Also, in June of 2008, the Arkansas Supreme Court considered the case of Sanders v. State. Sanders claimed that there was material evidence withheld by the prosecution in that a deal between the prosecution and a witness at his trial was not disclosed. In granting Sanders' petition, the court wrote,
Petitioner states that Watkins testified at the Rule 37 hearing that he had lied when he said Petitioner confessed to him, that he had no deal with prosecutors, and that he had been threatened by the prosecution with being charged as an accomplice to Petitioner if he did not testify against him. Harmon, the prosecutor, testified at the hearing that there was indeed a deal made with Watkins. As Watkins' testimony at Petitioner's trial was significant, and the defense could have impeached that testimony had it known of a deal, we find good cause to grant leave for Petitioner to proceed in the Circuit Court with a petition for a writ of error coram nobis on the claim that he was denied due process by the prosecution's failure to reveal a deal between Watkins and the prosecution.
Yes, here in Sanders, the Arkansas Supreme Court ruled that due process is violated when the state fails to disclose its deals made with a testifying witness in return for their testimony. Nevertheless, in March 2011, the court denied Tony's third and final petition. The only difference between this third denial and the other ones, this time the court was not able to say, as in their prior rulings, that
Petitioner falls short of establishing in this petition that there was a hidden plea bargain agreement between Gaddy and the state.
Still turning a blind eye to Pope's misconduct, the court said,
As with the prior two petitions, Petitioner's claim here fails because Gaddy's testimony was impeached at trial through a reading of the grant of immunity and questioning on cross-examination about her pending trial for the same murder. As was indicated in our previous opinion, the defense was not shown to be prejudiced by the alleged Brady violation, and disclosure of an existing agreement between the prosecution and Gaddy at trial was simply not likely to have produced a different result.
According to the Arkansas Supreme Court, the bottom line is, because the jury in Tony's case heard about use immunity, then for the jury to know about the other deals between the prosecution and Gaddy, it would not have made a difference in the jury's mind. However, we know that Juror Hampton's affidavit shows this finding by the court is erroneous. Also, this court failed to acknowledge the fact that the jury did not hear the truth about Gaddy's immunity. This in itself was harmful and prejudicial to Tony. Here is Gaddy's false testimony. Here Pope misrepresents Gaddy's immunity to the jury during his closing argument.
She didn't have immunity in here the other day. I don't want her to. That can be used against her.
Gaddy and Pope told the jury that Gaddy's immunity only protected her from the use of a videotape statement from being used against her, and that her trial testimony could be used against her. This lie is what the jury heard, and this makes it even more important for Tony to have been able to tell the jury about other rewards Gaddy received in return for her testimony. I don't mean to appear redundant, but it is important for us to cite these cases to fully show how many other courts have already determined that this type of flawed assessment and misbegotten application of legal principle used by the Arkansas Supreme Court to deny Tony really is. As seen earlier, Napier, and Tony's legal arguments are based on the same constitutional claims. In Neighbor's case, Hammer, a co-defendant and principal witness for the state of Illinois, testified in response to a question by the assistant state's attorney that he had received no promise of consideration in return for his testimony. The state's attorney had in fact promised Hammer consideration, but did nothing to correct the witness's false testimony. In Tony's case, Gaddy, a co-defendant and the principal witness for the state of Arkansas, testified in response to a question by the prosecuting attorney, Sam Pope, that she had received no promise of consideration in return for her testimony. Sam Pope had in fact promised Gaddy consideration, but did nothing to correct the witness's false testimony. In Neighbor's trial, the jury was told that a public defender had promised to do what he could for Hammer. In Tony's trial, the jury was told that Gaddy only received use immunity. In Neighbor, the Illinois Supreme Court found that the state's attorney had promised Hammer consideration if he would testify at Neighbor's trial. It further found that the state's attorney knew that Hammer had lied by denying that he had been promised consideration. However, the Illinois Supreme Court ruled that Neighbor was not entitled to relief, since the jury had been told that someone whom Hammer identified as being a public defender was going to do what he could in aid of Hammer and was trying to get something did for him. In Tony's case, the Arkansas Supreme Court ruled that Tony was not entitled to relief, since the jury had already been told that Gaddy received use immunity. In rejecting the Illinois Supreme Court's ruling in Neighbor's case, and which was the same conclusion that the Arkansas Supreme Court reached in Tony's case, the United States Supreme Court said,
"We do not believe that the fact that the jury was apprised of other grounds for believing that witness Hammer may have had an interest in testifying against petitioner turned what was otherwise a tainted trial into a fair one."
The reason why information regarding prosecution-provided benefits are so important to an accused defense is because disclosure of an agreement to provide such benefits, as well as evidence of the benefits themselves, can allow the jury to reasonably conclude that the witness had a motive other than altruism for testifying on behalf of the state. Such a finding can substantially impeach the individual's credibility as a witness. The greater the benefit, the greater the incentive is to lie in order to receive that benefit. We must keep in mind that use immunity did not prevent Sam Pope from prosecuting Gaddy for capital murder, nor from Gaddy receiving the death penalty. It simply meant that Pope could only use evidence against Gaddy that Pope already had in his possession prior to Gaddy being granted use immunity. So in reality, use immunity wasn't much of a benefit or incentive for Gaddy. On the other hand, having her charge reduced from capital murder to murder in the first degree, and receiving a 20-year sentence, making Gaddy eligible for release after serving less than 6 years in prison, certainly was. Each one of the cases that we have seen tells us that the jury needed to know about all the promises Pope made and or given to Gaddy. For a prosecutor to inform the jury of an insignificant reward promised to a witness while hiding and denying a greater reward is still an act of lies and deception that produce an unfair trial. Every person, even Tony, is entitled to a fair trial. The Arkansas Supreme Court's refusal to allow Tony a chance to contest the constitutionality of his conviction in itself violated Tony's right to due process of law. Rulings like the court made in Tony's case that so drastically deviate so far away from the very sound jurisprudence passed on to us from the United States Supreme Court should make us question ourselves and wonder if, through our vote, we have been electing qualified persons to hold a seat on our state's highest court. Over the years, the Arkansas Supreme Court has established a history of abusing its discretion as jurisdictional gatekeepers over writ of error coram nobis petitions. In a recent case, Howard v. State, in 2012, the court, while ruling in Howard's favor, still did a fantastic job in displaying their inability as jurisdictional gatekeepers to properly follow and or apply principles of well-established law consistent. Like Tony, Howard petitioned the Arkansas Supreme Court to grant jurisdiction back to the Circuit Court for a writ of error coram nobis. Before ruling on Howard's petition, the Arkansas Supreme Court held a hearing on its own to consider Howard's request. The contents of discussions during this hearing is what we'll focus on first. The following is a succession of questions and answers between the court, Howard's attorney, and an attorney for the state. Howard's attorney began his oral arguments to the court by stating,
Brady v. Maryland obligates the prosecutor of Little River County to disclose all impeaching and exculpatory evidence prior to trial. Because the prosecutor failed to meet this duty, so it falls upon the court this morning to assess how Mr. Howard was prejudiced by the default of the state's Brady obligation.
Because Braden made the comment, so it falls upon the court this morning to assess how Mr. Howard was prejudiced, one of the justices seemed unsure if Braden's comment was correct. Braden was interrupted and the following dialogue took place.
Mr. Braden, you said it's up to this court to assess the prejudice. Is that really the standard of review? Or are we to determine whether the trial court should determine prejudice?
Your Honor, what's happening here this morning is we're asking permission from this court to return to the circuit court to make some of these factual determinations.
So what is our standard of review then?
Your standard of review here this morning is, I believe, apparent merit. In other words, is there some merit, or basically a kind of a prima facie showing here? But that does necessarily involve at least some glance at the prejudice to determine whether there is some apparent merit to what happened.
So it's apparent merit? Not possible merit? Not potential merit, but apparent merit?
I think you can describe it in multiple ways. I think probably the easiest legal way to describe it is a prima facie showing. This court has used different terms over the years to discuss these standards, but I think basically it boils down to a prima facie showing this morning.
Counselor, the state speaks in terms of a reasonable probability. Are those words that we should use in assessing this?
The term reasonable probability falls into this standard of Brady analysis and the way that you look at it. Has Brady been violated? Is there a reasonable probability that the trial might have been different had the state met its obligation?
Do you believe it's the trial court's obligation to determine whether there's a reasonable probability that the outcome would have been different rather than our job?
It's kind of a bifold situation. The court has to assess that there is some prima facie showing. But yes, ultimately the circuit court, because ultimately that's a factual question, and this court doesn't make resolutions of fact. The trial court makes resolutions of fact.
So, following up on Justice Goodson, we don't make that determination then about reasonable probability. It's the trial court that makes that determination to decide whether to grant the writ or not.
That is correct, Your Honor. You have it absolutely correct. But I do think that we have to make some minimal showing because that's what this court has said in its opinion. There has to be some minimal showing, or apparent is one term, or prima facie showing. And we have done that. We have met that in what we have presented to this court.
When we hear justices comment,
Is that really the standard of review?
and the defendant's attorneys say,
Your standard of review here is apparent merit.
So it's apparent merit, not possible merit, not potential merit, but apparent merit? The state speaks in terms of a reasonable probability. Are those words that we should use in assessing this?
the court further asks,
Do you believe it's the trial court's obligation to determine whether there's a reasonable probability that the outcome would have been different rather than our job?
the attorney answering,
I think that this court has to assess if there is some prima facie showing. But yes, ultimately the circuit court, because ultimately that's a factual question, and this court doesn't make resolutions of facts. The circuit court makes resolutions of facts.
making it easy for us to deduce that the justices of the Arkansas Supreme Court are not at all clear on what procedural applications of law must be used during their review of requests to reinvest jurisdiction to the trial court. As the hearing continues, a justice asks,
So, in order to reinvest jurisdiction with the trial court, you need to, first of all, show due diligence, and then, coining your phrase, apparent merit. Can you talk about how you exercised due diligence in this instance?
Mr. Braden begins to answer when he is stopped.
I'm going to cut you off once again. Isn't that for the trial court to determine whether he was diligent or not? Isn't that what we said in the Cloyd case? Do we make that determination at this juncture? Maybe you're saying the same thing on all of these issues of reasonable probability and due diligence. You have to show enough that there is a factual question for the trial court to decide. Is that basically what you were saying? That's the test? You have to lay a foundation so we can't say, as a matter of law, you didn't do due diligence, or as a matter of law, there's no reasonable probability that the verdict wouldn't have been different. So you have to make a prima facie case or apparent merit on due diligence and reasonable probability to get the case back to the trial court. And then the trial court makes those factual findings. Is that correct?
This is in 2012 when Howard presented these arguments before the Arkansas Supreme Court. Yet, the court is still unsure of what their position should be in determining whether or not to grant jurisdiction back to the trial court to consider a post-conviction petition. Remember, it was 1935 in the case of State v. Hudspeth when the Arkansas Supreme Court made its ruling that
no application for the writ of error coram nobis may be made to the trial court without permission to make such application has been given by this court.
But here, in 2012, we hear the justices of the court talking as if they must figure out just what this is all about. The procedure used by the court to reinvest jurisdiction back to the trial court is not something new. Wallace v. State, 1971.
Appellant made a prima facie showing.
Poe, 1985.
Poe now seeks permission to file a Rule 37 petition in the trial court and present a sufficient prima facie showing to justify a hearing.
Leisure, 1973.
Contrary to the inference drawn by appellant, we disavow any intention or inclination to conduct a review of the records submitted upon appeal in an effort to determine whether there is merit in an allegation before granting or denying permission to a petitioner to proceed in the court of original jurisdiction.
After having the discussions during Howard's 2012 hearing, this is what the Arkansas Supreme Court concluded.
The reasonable probability standard applies to the circuit court's evaluation of the merits of the error coram nobis petition and not to this court's decision to grant permission to proceed with filing the petition in circuit court. This court will grant permission for a petitioner to proceed in the circuit court with a petition for writ of error coram nobis when it appears the proposed attack on the judgment is meritorious. In making such a determination, the court looks to the reasonableness of the allegations of the petition and to the existence of the probability of the truth thereof. Howard's claim of a possible Brady violation has apparent merit that warrants reinvesting jurisdiction in the circuit court so that he may pursue a petition for writ of error coram nobis.
Tony did not do anything different than Howard, also Buckley, Newman. All four of them simply petitioned the Arkansas Supreme Court to reinvest jurisdiction to the circuit court. Yet Tony's cases were treated differently. In Howard, Buckley, and Newman, the court openly said that it was not their job nor duty to determine if the defendant was prejudiced by the alleged Brady violation. However, this is exactly what the court has done in all three of Tony's petitions. When the Arkansas Supreme Court ruled on the merits of Tony's claims and said that Tony was not prejudiced by the alleged Brady violation. Jeff Rosenzweig was the attorney that filed Tony's third petition. He advised the court of their duty when he included this statement within the petition itself.
At this point, the question is not whether Thrash is entitled to relief, but whether he makes a sufficient showing for remand for a hearing thereon.
But instead of adhering to and following Jeff's correctly stated judicial procedure, the Arkansas Supreme Court found and
As was indicated in our previous opinions, the defense was not shown to be prejudiced by the alleged Brady violation, and disclosure of an existing agreement between the prosecution and Gaddy at trial was simply not likely to have produced a different result.
No, it was not the Arkansas Supreme Court's job nor duty to make this decision against Tony, unless the court could strictly, as a matter of law, determine that Tony did not receive an unfair trial and was not shown to be prejudiced by Gaddy's false testimony and post-Brady violations. As we've already seen from our review of the many cases and court rulings, even if the Arkansas Supreme Court was in a proper position to make such a determination, it would still be incorrect, an unreasonable application of clearly established law, which means that not only Tony was denied a fair trial, he has also continuously been denied a fair opportunity to seek proper relief. It is mind-boggling and depressing to think that our state Supreme Court can be so complacent in its review of cases like Tony's. Do we want our state's highest court to send out such a strong impression that says it is fair play and all right in a criminal prosecution for a prosecutor to lie, deceive, and manipulate evidence and witness testimony, as Sam Pope has done in Tony's case? Well, as long as Tony's conviction stands, then this is exactly what we are doing. Between 1997 and 2009, a total of 89 petitions for error coram nobis were filed. 5 were granted, 67 denied, 15 were disposed of by other means, with 2 pending. Less than 6% of the applicants were given an opportunity to fully present their testimony and evidence in front of a qualified fact finder and in the proper judicial forum, the circuit court or court of original jurisdiction. With today's technology, anyone can get on a computer, go to the court's website, and review the court's opinions on each and every one of these cases. The scariest part about seeing such a low number of requests being granted comes from the fact that when a person does actually make such a review of the court's opinions, it is easy to see the inconsistencies by which this court has applied proper versus improper standards of review and proper versus improper applications of law. Here are a few examples. In 1997, the Arkansas Supreme Court granted Gregory Larry Moore's petition to have jurisdiction returned to the circuit court. But in granting Larry Moore's request, the court gave the circuit court this order.
As the trial court considers whether to grant the writ, the following guidelines are applicable. The function of the writ of error coram nobis is to secure relief from a judgment rendered while there existed some fact which would have prevented its rendition if it had been known to the trial court, and which, through no negligence or fault of the defendant, was not brought forward before rendition of judgment.
A problem for the Arkansas Supreme Court in Larry Moore's case came when the trial court refused to follow the order given to them by the court. The trial court judge that ruled on Larry Moore's petition knew that the Arkansas Supreme Court gave an improper standard of review for determining whether or not a defendant had been prejudiced by an alleged Brady violation. Therefore, instead of applying the stringent and improper standard that the Arkansas Supreme Court ordered the trial court to use, the trial court judge chose to apply the correct standard, which for years had been handed down from the United States Supreme Court. The trial court judge found that
the evidence was material to the guilt and punishment, and that if the evidence had been disclosed, there was a reasonable probability that the results of the proceeding would have been different.
because the circuit court judge did not apply the more stringent standard of would have prevented the rendition of judgment, as the Arkansas Supreme Court ordered, but instead granted Larry Moore a new trial based on the United States Supreme Court standard for determining when prejudice results from the prosecution's failure to disclose exculpatory or impeaching evidence. Then, the attorney for the state shouted foul, foul, and thus the state appealed the circuit court judge's ruling to the Arkansas Supreme Court, arguing that
the standards for error coram nobis are higher than those which must be met to find a Brady violation, and that the evidence presented to the trial court did not rise to the level required to grant appellate petition for the writ and for a new trial.
it was this appeal filed by the attorney for the state that put the Arkansas Supreme Court on the spot. In order to reverse the circuit court's decision, as the state's attorney requested in their appeal, the Arkansas Supreme Court would have to find that the circuit court judge abused its discretion in granting Larry Moore's writ of error coram nobis and a new trial. But obviously, the court could not find that the circuit court judge was wrong in following a standard determined to be used by the United States Supreme Court. The Arkansas Supreme Court was forced into a position where they had to admit that they made improper and inconsistent rulings in the past. In Larry Moore 2000, the Arkansas Supreme Court stated that
We note that at different times throughout our jurisprudence, we have used different phrases to articulate the standard for determining whether a petition for a writ of error coram nobis should be granted. Specifically, we hold that in our review of the granting of a petition for a writ of error coram nobis in this case and all future cases, we will determine whether there is a reasonable probability that the judgment of conviction would not have been rendered or would have been prevented had the exculpatory evidence been disclosed at trial.
not being able to say that the circuit court judge abused its discretion by applying the United States Supreme Court standard, while also knowing that this judge's ruling had exposed the deficiency within their own ascribed standard. The Arkansas Supreme Court tried to save face by enunciating a change in the language of their standard, which included the phrase reasonable probability. Yet beyond the fact that making this change in their standard let us know that for years the Arkansas Supreme Court used an inadequate standard to deny prisoners opportunity to have their claims heard by the circuit courts, but we also can recognize that by simply adding the words reasonable probability did not actually cure the true deficiency in the court's application of law, nor did it prevent the court from being notably inconsistent in their review procedures. Here it is in a nutshell. In Larry Moore 1997, the Arkansas Supreme Court said,
"The function of the writ of error coram nobis is to secure relief from a judgment rendered while there existed some fact which would have prevented its rendition if it had been known to the trial court."
In Thrash 1999, the court told Tony that,
"Before a writ of error coram nobis may issue, it must appear that the facts as alleged as grounds for its issuance are such as would have precluded the entry of the judgment had they been available at trial, not that such facts might have produced a different result."
in Larry Moore 2000, while it was noted that the trial court judge applied the United States Supreme Court standard of
Whether there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different.
because the trial court applied this standard, the Arkansas Supreme Court changed the language in their would have prevented its rendition standard and said,
"We hold that in our review of the granting of a petition for a writ of error coram nobis in this case and all future cases, we will determine whether there is a reasonable probability that the judgment of conviction would not have been rendered or would have been prevented had the exculpatory evidence been disclosed at trial."
This was in the year 2000 when the Arkansas Supreme Court decided that
In all future cases,
the court would apply the standard as announced in Larry Moore 2000. Nevertheless, in the ruling Tony received from the court denying his second petition in the year 2003, the court said,
before a writ of error coram nobis may issue, it must appear that the facts as alleged as grounds for its issuance are such as would have precluded the entry of the judgment had they been available at trial, not that such facts might have produced a different result.
we just have to ask this question here. Why didn't the court apply the Larry Moore 2000 reasonable probability standard to Tony's 2003 petition? There is no question. The court is treating cases differently. The question is why. We can go back and see in Cloyd 2002, the Arkansas Supreme Court stated that
The trial court must decide whether there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different.
this standard expressed by the court to be used in Cloyd is quoting verbatim the same words used by the trial court judge when granting Larry Moore a new trial from his 1997 petition, and the same words used by the United States Supreme Court as a standard for determining if prejudice has resulted from a Brady violation. Cloyd also gives us a chance to view in action the inconsistencies in which the Arkansas Supreme Court has ruled on individual cases. The court said in Cloyd that
The trial court must decide whether there is a reasonable probability.
on the other hand, in Larry Moore 2000, we see where the court said,
We will determine whether there is a reasonable probability.
you cannot have it both ways. This is why we heard all the confusion coming from the justices during their discussion in Howard's 2012 hearing. Some justices of the court believe that one procedure should apply, while other justices recognize the correct procedure, that by law they are required to follow. It isn't hard to discern which one of the two enunciated procedures that by law is correct. The correct review procedure is matched with the words of the correct standard of review, the standard which is given by the United States Supreme Court. The inconsistencies of the court rulings continue.
To merit relief, the petitioner must demonstrate that there is a reasonable probability that the judgment of conviction would not have been rendered or would have been prevented had the information been disclosed at trial. The circuit court must determine whether there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. To merit relief, the petitioner must demonstrate that there is a reasonable probability that the judgment of conviction would not have been rendered or would have been prevented had the information been disclosed at trial. The circuit court had to determine whether there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different.
Each and every one of these cases presented the exact same claims to the court, which alleged that the state failed to disclose exculpatory or impeachment evidence. Yet the Arkansas Supreme Court has applied at least 4 different phrases as a standard to be used for determining whether prejudice ensued from the failure of a prosecutor to disclose materially favorable evidence to the defense. We know that the standard given by the United States Supreme Court is correct. We can be sure that the Arkansas Supreme Court would not have felt the need to announce a new standard in Larry Moore 2000 if their old standard was already compatible to the United States Supreme Court standard. When we look at the standard used by the Arkansas Supreme Court in denying Tony's first and second petitions, we find that the words would have precluded the entry of the judgment came from a 1944 Florida State Supreme Court case, Thompson v. State, which the Arkansas Supreme Court cited in their Larrymore 1997. In Larrymore 1997, the Arkansas Supreme Court made this Thompson 1944 cite in reference to a claim brought under newly discovered evidence and had nothing to do with the prosecution's failure to disclose favorable evidence or the known use of perjured testimony. This Thompson case from Florida has nothing at all to do with Tony's case, nor Tony's allegations of prosecutorial misconduct. But what it does show is how the Arkansas Supreme Court will say and use anything to appear justified in denying a person's relief. If we know that the standard given by the United States Supreme Court is correct, then why is it that the Arkansas Supreme Court has used the exact language of this standard in only a very few cases? We can easily discern from the words in each of the varying standards used by the Arkansas Supreme Court that they all carry a different meaning. The language from the United States Supreme Court is,
if there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different.
although the constitutional duty is triggered by the potential impact of favorable but undisclosed evidence, the court has also said that
A showing of materiality does not require demonstration by a preponderance. The disclosure of the suppressed evidence would have resulted ultimately in the defendant's acquittal.
Bagley's touchstone of materiality is a reasonable probability of a different result, and the adjective is important. The question is not whether the defendant would more likely than not have received a different verdict with the evidence, but whether in its absence he received a fair trial, understood as a trial resulting in a verdict worthy of confidence. A reasonable probability of a different result is shown when the prosecution's evidentiary suppression undermines confidence in the outcome of the trial, undermines confidence in that the verdict resulted from a fair trial versus a verdict resulting from an unreasonable probability. Arkansas Supreme Court.
If there is a reasonable probability that the judgment of conviction would not have been rendered or would have been prevented had the information been disclosed at trial.
This is the language from the Arkansas Supreme Court when the court announced in Larrymore 2000 that this standard should be applied to Larrymore's case and in all future cases during a review of error coram nobis petitions. The words used in this standard, judgment of conviction, would not have been rendered or would have been prevented, expresses a review that turns on a different result, being one where the verdict would have been ultimately to acquit. Obviously, these two very different standards require two very different results. The United States Supreme Court standard turns on whether the defendant received a fair trial. The Arkansas Supreme Court standard turns on whether the defendant would have been found not guilty. This has to make us wonder if the Arkansas Supreme Court has concern for whether a defendant in an Arkansas court has received a fair trial or not. In all three of Tony's petitions filed to the Arkansas Supreme Court for relief, Tony presented at least two claims. The prosecution failed to disclose favorable evidence to the defense, and the prosecution knowingly presented false testimony. Yet in denying Tony's first and third petitions, the court said nothing about Tony's argument that Prosecutor Pope knowingly presented false testimony. In Tony's second denial, the court did acknowledge that Tony had brought this claim to the court, but the court never directly addressed this claim, other than simply quoting the 1944 Thompson, Florida case out of Larrymore, 1997, to appear justified in denying Tony's petition. The Arkansas Supreme Court has basically treated Tony's claims as being the same, as far as errors being committed by Sam Pope, and thus all deserving of the same review. However, the United States Supreme Court has acknowledged three situations in which Brady claims might arise. 1. Where previously undisclosed evidence revealed that the prosecution introduced trial testimony that it knew or should have known was perjured. 2. Where the prosecution failed to accede to defense requests for disclosure of some specific kind of exculpatory evidence, or where the prosecution failed to volunteer exculpatory evidence never requested or requested only in a general way. In United States v. Argus, the court has also stated the well-established rule of reasonable likelihood.
A conviction obtained by the knowing use of perjured testimony is fundamentally unfair and must be set aside if there is any reasonable likelihood that the false testimony could have affected the judgment of the jury.
At no time has the Arkansas Supreme Court even attempted to apply this reasonable likelihood standard announced by the United States Supreme Court as the standard to be used when reviewing claims that the prosecution knowingly presented false testimony in Tony's case. It is also worth noting that when a case presents the exact same set of facts, which proves that the same type of error has been committed, yet a court reached a different result, this ruling would still be an unreasonable application of well-established law and violates a person's 14th Amendment right to due process and equal protection of the law, even if the reviewing court does analyze the case under a correctly stated standard. The purpose for the United States Supreme Court in determining what set of facts or particular actions constitute a constitutional violation and the appropriate resolution for such unlawful action is so that every lower court in the land can have the same correct blueprint to follow that would then allow them to uniformly apply the law equally and fairly to everyone. But it is still up to the lower courts to apply these correct standards and procedures to each case. If a court fails to do so, the court itself then violates the law of the land. In quoting the Argus court again,
Conviction obtained by the knowing use of perjured testimony is fundamentally unfair.
why hasn't Tony been given a new and fair trial? The United States Supreme Court Justice Thurgood Marshall said,
It is the state that tries a man, and it is the state that must ensure that that trial is fair.
We have seen from the court's own rulings that there is an alarming degree of confusion and inconsistencies among the justices of the Arkansas Supreme Court when it comes to applying well-established law or following procedures in their own position as jurisdictional gatekeepers over writ of error coram nobis petition. There is no wonder as to why, over a 12-year period, only 5 requests were granted out of 89 petitions filed into the court. If we cannot rely on our state Supreme Court to protect us from oppressive and forbidden acts of tyranny carried out at the hands of elected officials that care more about building their own reputations and road to positions of power than they do in upholding our federal and state constitutions or our governing laws, then how can we continue to believe that our beautiful America is still the home of the free and land of the brave? It is sad to say, but as an Arkansan, our courts have made it to where I have absolutely no confidence in the fairness of our state's judicial system. What more can Tony and Jean do? Out of all the evidence that Tony and Jean have presented to the courts over the years, which proves Tony did not receive a fair trial, that his conviction was based on perjured testimony. Not once has Tony ever been given an evidentiary hearing in order to properly present the facts of his case before a judge sitting in the proper position as fact finder. Like every child, Tony was born equal in the sight of God and endowed with certain unalienable rights, such as life, liberty, and the pursuit of happiness. During the Vietnam War, Tony sought to serve his country by enlisting into the United States Army at the age of 18. In knowing the truth of their story, do you believe that Tony should have been cheated out of life and his liberty and forced to die in prison?